All. This is Dr. Mobeen Sayed from drbeen.com. Welcome to one more show. So, with us today, we have Paul Bork, our own Paul Bork, who is a lawyer as well. And as you all suggested, many of you, that hey, why not we have the legal COVID landscape reviewed by Paul. So here we are with the first episode. If you like it, we'll continue with the series. If you didn't, then this is the episode. So, Paul, thank you very much and take it away.
You're welcome. Thank you, Mobeen. So here we are. We're going to talk about some of the legal concepts and focusing on the cases that we've already talked about and get in a little more detail and explain a little more about how lawyers might look at it, how we can identify cases and distinguish them to go forward. And at the end of this, you may actually know more and be better able to do it than even some of the counsel that we've seen arguing. So hopefully we can do that for you. So the first thing is to really understand the Jacobson versus Massachusetts, the 1905 cases. And most lawyers talking about it just read some of the stuff and go forward, and they don't really understand the context of this. But let's go over some of the things that were actually happening here. You know, Massachusetts passed a statute first, as the first thing, and that's what the court talks about. And under that statute, they delegated the authority to boards of health for various creatures of the state, one of which was the city of Cambridge. You may have heard about Cambridge, Massachusetts for some bizarre reason. But anyway, the city of Cambridge, their board of health, enacted a regulation, and it's in a Boston suburb, and dealing with the smallpox population. And they said, all people not protected by a vaccination after March 1st, 1897 need to be vaccinated or revaccinated. Now, it's interesting that and so they know that vaccinations needed to be done again and that they were waning. Apparently, what the Cambridge Board of Health knew in 1897 was brand new news for the CDC because they weren't aware that any vaccination waned. Or maybe they just thought it was different. And it was a very long epidemic that was going on. Because the law was passed, Cambridge passed their regulation, 1897, on July 17th, 1902. That's like 5 years. Jacobson, who was an adult, at that time it meant over 21, was offered a free vaccination. Our government's still offering free vaccinations. And legally important, and he probably didn't realize it at the time, he didn't provide a reason to the board. There was no process defined in the regulation that they could take anything into account, but later on, the court held this against him and essentially knocked out all of the arguments he had because he had not presented them before. And this is a common legal doctrine that if you don't, you need to exhaust your administrative remedies. And so what that means is that one of the ways it's enforced is if you're arguing on appeal as you move up, you can argue anything to support what the lower court did, but you can only argue those things you argued below in order to overturn it. And sometimes when people will argue something and then they won't argue it at the Court of Appeals, they'll argue it at the district court, but not at the Court of Appeals. And then when it goes up to the Supreme Court, they'll say, well, you abandon that logic, you abandon that rationale or that argument. And so there's a requirement to do that. And so it was very important that he had not done that. And there was a criminal complaint, and he pled not guilty. And all of the defenses that he suggested or tried to raise in the criminal enforcement of it, remember they're trying to fine him $5, they said were immaterial, irrelevant. Because he had gone through the process, he was addressed, he was asked to be vaccinated, and he said no. And the criminal statute says that if you're over 21 and you decline the free vaccination, you pay $5. And so the defenses he wanted to raise were viewed as immaterial to the crime because it didn't say if you don't have a good reason, you're fined. It said if you don't do it, you're fined, if you don't take the vaccination. And then he requested instructions to the jury. Those were denied. He was convicted. He went on appeal. They overruled every exception he had, and the conviction was upheld. But let's understand a little more about what really was going on. This vaccination was only taking place in South Boston. Boston itself was not doing that. And they had about 10,000 people vaccinated out of the 615,000 people that were living in the greater Boston area. Some of you may be familiar with Boston, and South Boston, or Southie as it's called, was a very densely populated residential neighborhood with a very strong Irish American heritage. So we had trouble with immigrants going way back. This is actually from the Boston Globe, this page right here. You can take a little time to take a look at some of the things that they're having here. And here it says that they had 115 physicians that were at work to do the vaccination. And we had this area where we had a lot of Irish. In the Supreme Court's case, they pointed out that Ireland was one of the countries that had the lowest vaccination rate of the countries they were talking about. And so here we have these new immigrants who came over very poor. Some of you may have heard about the potato famine that took place there. And when people immigrated to the U.S., I guess the Irish always liked to have a good wake for people when they died. And so they'd have a white wake when they would go to America because transportation was so difficult and the food was continuing down for a long time and they weren't expected to come back. And so here we have that our Jacobson, okay, and let's say here, we had a lot of them, thousands. This is from an article that the Boston Globe had that accompanied the picture. So that thousands came to America from Ireland between 1845 and 1850. And Boston was one of the main seaports of their landing. And many Irish immigrants, barely had the means, no money. And in 1850, 35,000 of Boston's 136,000, or 26%, were Irish. And they were living in the poor central area. And when smallpox was coming in, we had smallpox epidemics periodically, and cowpox, the vaccination had been done a fair amount. Well, we had done, I don't know if we were using cowpox then or we were just exposing people to a small dose of smallpox and through their arm or whatever. But probably a lot of the Irish were viewed as being sickly. They were being viewed as immigrants. They were viewed as dirty. They were viewed as not being as vaccinated. And so they had a program to go do it. And they were paying for it. The city was paying for it. And Jacobson declined. He was a pastor. Now, interestingly enough, most of the Irish that were coming over were Catholic. And being a pastor, my bet is he wasn't Catholic, or he wouldn't have taken the term pastor. He would have had the priest because Catholic leaders are called priests and not pastors, unless the newspaper makes that up. Said that the forced vaccination violated his religious rights. And the defenses he had sort of were, the vaccine doesn't work in general. Countries which vaccinate and those that don't have about the same. He said New York has most of the immigration, and even they don't require it. And he had personally had a prior vaccination, and he and his son both suffered from it. And he said that the board was arbitrary in what they were doing. There was no hearing that was given to him. He was simply turned over and fined, just like a ticket for speeding or something. We just given a ticket and showed up, and the court wasn't interested in why he thought that the board should have made a different decision, should have waived it, should have looked at whatever. They were simply looking at, you were given the vaccination order, you didn't do it, where's your $5? Now, he refused to pay the $5 and got a felony in the enforcement process and made it criminally much worse for himself. And Massachusetts was arguing our legislature decided, and the courts cannot listen to conflicting expert testimony as to the efficacy or hurtfulness of vaccination. The legislature is the only body which has the power to determine who is in the right. And second, they argued that Jacobson should have provided the reason to the Board of Health. And they said, nobody said the Board of Health was unreasonable. And if you had just talked to them, they would have understood and you wouldn't be here now. And just because you failed to raise your concerns at the right point is the only reason you're here. Now, they didn't say, there's X hundred of people that have raised it and the board responded appropriately, but they pointed that out, and the court thought that was a good idea. So any questions or concerns as I go through this?
So far, so good. I am busy commenting. So people, if you are seeing Cool Beans, if you're seeing me this way in my picture, I'm not sneaking away. I am looking at your chat, which is here. Sorry, back to you, Paul.
That's fine. I have the same thing. My presentation is here and you're over on the side. So if I'm looking at the side, I'm looking to see that. So the defendant raised 15 different grounds. The Supreme Court said that the grounds he raised were more numerous than effective. There's a principle in law that goes back before the copy machines, when people would bring the law books in. And they said, if someone comes in with an armful of books, you're okay. If they come in with one book, you have real trouble because they found one case they want to rely on, and basically it's been decided, you lose. And so this is the same sort of thing. If someone has 15 different grounds, it's usually because they're flailing away. They don't know how any of these are better than the others or whatever. The Supreme Court and most courts limit how much space you can take up arguing. And even if they didn't, there's a limit to how many words people will look at for your case. And if you're raising 15, you're telling the court none of them are any good. And when I was clerking for the court, I would have the same view when someone on appeal from the district court to the circuit court would, exert 20 different grounds or something. You're like, that one's wrong. They're all wrong. Okay, that's for that reason, that reason. Oh, I don't understand. Oh, that's why that one's wrong. It almost always turned out to be true. So often when you see this, clients will look at it and say, oh my gosh, the lawyer is arguing voraciously for me. But the bottom line is, if he had one good ground, he would only argue the one.
That makes a lot of sense.
Just like good trial lawyers, and they all aren't good, even on this standard, they're going to have a closing argument why they should win. If there's something they're not going to mention in their closing argument, why are they spending time introducing it? It's just silly, waste of effort, because it's not important to their argument why their client should win. They're just distracting. They're potentially having trouble. Same thing with these arguments. If he had one good argument or perhaps one in the backup, he would go forward with it, but 15 tells people that there's really nothing here.
So, Paul, there are questions that I have no idea how to answer them because they are legal questions and I am not a lawyer at all. So check this out. Mean Bean says, did the FSMB control the state concerning this Timon scheme? Then there is another question from Colleen. Is that the inexperience of the defendant lawyer?
Interesting you say that. I'm reminded of this in a sales area. There are two salesmen that were working for a big car sales firm, and they lost their sales manager, and the manager promoted one of the younger men into that role. And one of the older people said, I got far more experience than he does. And apparently the general manager says, no, you don't. He's got 5 years experience. He says, I've been here 30 years. He says, yeah, you have 1 year of experience 30 times. Some people learn more than other people. So my bet is this is probably someone who would argue the same way with 20 or 30 years of experience as they did when they had their first whatever with it. So yeah, it probably wasn't lack of experience. It was probably just lack of expertise. Or alternatively, maybe all the cases he has, there's no good reason for it. He's constantly flailing away. One of those would be the people that are frankly representing criminal defendants. Because the criminal cases are all the same. Your guy actually did it. He went in, he confessed to the police. They have evidence on it, and now you're trying to get him off. Yeah, there's occasionally a person who's really innocent, but the vast majority of the time it's just, oh, did the police mess up the evidence enough so that the evidence that shows he really did it can't be taken into account and causes trouble. When I was first clerking, I asked my judge, I see all these exclusionary rule cases in law school. How important are they? And the judge says, they're of no importance at all. He said, in the 5 years I've been on the bench, there's been one successful motion to exclude evidence. The police learn how to do it, and the exclusionary rule is very important because it means the police know that if they don't follow the rules right, the evidence doesn't come in, they don't win, their guys get upset. Because the other option would be, oh, the police make a mistake, break my door down in the middle of the night, and they were looking for a house someplace else. I sue the local police officers. Guess how that's going to work? I'm going to get to be on a first name basis with these officers, right? Oh, we're just looking for traffic offenses, going to follow you around all day. No. And if you win, they don't have any money. So there really is no remedy except for the exclusion, and then the people that the police are collecting the evidence to help out, they say, wait a second, Joey, we can't use that because you didn't do whatever. Do it right next time. So that works particularly well. So this person may well be a lawyer that got started representing people with frivolous cases, and maybe he just continues to do it, or maybe this is just one where there really wasn't anything that he found he could argue.
Got it. Thank you.
And the court said we cannot second guess the legislature. Now, you know, the court always second guesses the legislature. So this is one of the early cases, 1905, when before the court really did a lot of that. And they also said, we don't want to say we're never going to second guess the legislature, but this isn't the case we're going to second guess them, because what they did they thought was pretty good. Now here comes the way you can distinguish the case. And from a legal perspective, distinguishing a case means, yes, the case you cited is right, but it's different than yours. It's been distinguished. Well, and sometimes the distinguishing things aren't that different. That was a truck, not a car, that ran into me. So the case is completely useless. Well, maybe it is, maybe it isn't. It depends. But for example, we heard that when the CDC arguing in the Fifth Circuit said, well, what about the notification we did when people were boiling meat in NyQuil and we told them not to do it? The judge said, that's not a prescription drug. Why are you talking about it? It's like, that's completely distinguishable, has no relevance here. It's gone as if it didn't take place. And the same sort of thing can be done here, I think, with Jacobson applying to the COVID case based on the facts. Here's some of the things that the court said, and we didn't have these brought out to be distinguished in any of the opinions and arguments that I saw. The court said the matured opinions of medical men everywhere, now you could read it in doctors or medical men and women everywhere, and the experience of mankind, as all must know, negative, that means makes improper, the suggestion that it is not possible in any case to determine whether a vaccine is safe. So what they're saying is they're believing that the vaccine is safe. So the Jacobson court was working with a safe vaccine. If we can show that the vaccine has huge side effects because of the virus, because of this case, because of this opinion, we can say the Supreme Court was talking about a safe vaccine. Mine isn't safe, so they might have well have decided differently. They did agree that some learned physicians hold contrary views. And they had exceptions were implied. They said if he could show with reasonable certainty that he was not a fit subject for vaccination at the time the vaccination was offered, not at the time of trial, that could have been accepted, or that the vaccination would seriously impair his health, or this one's pretty hard thing, probably causes death, not just perhaps, as it's more likely than not to kill him, then we think maybe he has a good argument not to take the vaccine. So what this means is if we have someone who can get a medical determination that says whatever seriously impaired their health is, and we can go back, people will go back and look at what they said there, but let's just take this on its surface. If I have a doctor that says if my client gets a vaccine, it will seriously impair his health, or to a degree of medical certainty, it will probably cause his death. You can say this, the Supreme Court and Jacobson said that's not the case we're looking at. And so by its own words, the court said, we're deciding the case in front of us and we're saying this doesn't read all the way across. They also said that their decision would be the same if the legislature selected an effective way to address smallpox, not the most effective way. Now, the court was convinced vaccination was the most important way, but they said, went out of their way to say the legislature isn't required to pick what we judges may second guess and think is the most effective way. They just have to pick something that is an effective way. Well, right now, as you know, we go in and we look at the efficacy of the vaccine against COVID. Can we argue?
Something happened to your sound. I don't know if it is you. I think you accidentally muted yourself. So you are mute. So I think it is Control D. If you press, you will unmute yourself. Let me see if I can unmute you. Can't, the mic is not connected. Okay, so so Paul is back. Yeah, so I think we lost you for a few seconds.
Yeah, I turned him off and back on. So are we still on?
Yes. Can you hear me?
Yes, I can hear you.
Absolutely. So we're on. Okay,
very good. So anyway, they said if the legislature selected an effective way, they would still decide it. So sometimes when a court decides something, they go out of their way to say, well, this case is right. And if it were, 3 steps over, it's still going to be right. But 5 steps we're not talking about, and 10 steps, no, we're not going that far. Sometimes they distinguish that as they go forward. And as they said here, this vaccination, if he had at the time that he was not a fit subject, showing that it would seriously impair his health, or it would probably cause his death, or he was not a fit subject for vaccination at the time under the regulation, because they said all infants, people under 21, were not fit for vaccination at the time. And whether that was they weren't fit or the state didn't want to pay to vaccinate all the little kids, and if they died in the Irish slums, who cared? I don't know, but one can guess. Okay, next. The Supreme Court cited an Encyclopedia Britannica article, and the court is allowed to go off and find references that are viewed as credible or that a person of interest in the community would go find and know those things and take judicial notice of it. They're required to tell people, but they're allowed to go do some of those things. Not allowed to do their own research or call their own friends, like what happened in Roe versus Wade, but that's a different thing. But they Encyclopedia Britannica article about vaccination, and it listed which countries had adopted it, which countries hadn't. It's a collection of information. So just like a Google search today. We just get it updated a lot more. Anyone remember the old Encyclopedia Britannicas and the yearly books that would come in? And if you're looking for your article, go check and see each year if it had been updated. Yeah, well, we used to have to do that. And then the really important thing is they cited a New York Court of Appeals case. I don't know how many of you are aware, but the New York Court of Appeals is their Supreme Court, and the New York Supreme Court is their trial court. Because the New York legislature didn't like their court when they were creating their Supreme Court. So they left all the people that were on the Supreme Court at the trial level and created a court above them. And that's why it's the New York Court of Appeals.
Very interesting. I did not know this.
Right. So if you see a New York Supreme Court case, don't jump up and down and say, oh, yeah, that's an appellate court. No, that's the trial court. So anyway.
Got it.
So this was a New York appeals case, and they probably sent it to the Supreme Court, or the Supreme Court went out looking for it because it's another case about smallpox when the Supreme Court is looking at it. And they want to see what other courts have done. The Massachusetts court system did nothing. I mean, they were viewed as, we're enforcing a fine. He violated the rules of the fine. I mean, there's nothing to help them understand vaccine. There's no, oh, we look at what this person said and that person. So when it gets to the Supreme Court, 2 or 3 people have done it before. It's a lot easier to be brilliant if you see other people's arguments. Well, in this particular case, they had nothing. They say, oh yeah, he argued all these things. We didn't listen to him. Yeah, he argued those things. We didn't let him do it. He didn't pay the fine. He didn't do it. He got fined. That's it. It's like, so they went out and they looked for the Encyclopedia Britannica to learn more about vaccination. They went out and they found this New York Court of Appeals case. I say they found it because when they cited it, it hadn't yet been published. But hey, if you're a state court and the Supreme Court asks you for a copy of what you've just done and it's been done but just hasn't been published, you might be willing to send them a copy of it, right?
Yeah.
So they weren't citing medical papers because that process hadn't been established yet, but they were citing, there was an epidemic in Chemez, I don't know where that is, in 1870 to 1871. And whatever report they had, I think this is a report that from the board, the medical board. And I don't know how the New York court got it. The New York court probably got it because one of the parties argued in front of them, did their job and went out and found stuff and brought facts in. They had a case, 64,255 people over a 2 year to 2 year period, 83% vaccinated. They have pretty good vaccination coverage. 1.77% got infected of those, and 0.73% died. 8.98% were unvaccinated. 46% of those got infected, and 9% of those died. And 7.24% had a prior infection. They didn't talk about them at all, so my bet is that prior infection meant they didn't get infected and they didn't die. Because I always heard smallpox was a one and done. So here we have a 6-fold lesser infections, 68-fold lesser deaths. So that says an 83% efficacy for infection and an 89% efficacy for death. Then they cited apparently a correspondence from the medical officer for the London Government Board in 1881. And there they said that adult people vaccinated had 90 out of a million got, and 3,350 out of a million died. And The ones that were less than 5-year-olds, 42.5 out of a million got it, and 5,950 died. So this is showing a 97% efficacy for adults and a 99% efficacy for children for the death. And so the court here said, so again, if someone had a case here and you're in court, not that you would be arguing it, but if you're in court and someone says, oh my gosh, go look at this Jacobson case, you can say, well, if you've got a 99% efficacy, we can talk about it. If you're at 0%, I guess it's not the same thing.
True.
And they said, while we do not and cannot decide that vaccination is preventative of smallpox, because clearly some of the people that got vaccinated got it and died, we take judicial notice of the fact that it is a common belief of the people of the state. And with this fact as a foundation, we hold the statute in question is a health law enacted with a reasonable and proper exercise of police power. So the people governing, the legislature and the people governing have to do things properly. And if the people are all deluded and have the wrong idea, the government going along with a common view is not arbitrary and not something that the courts are going to second guess and say, oh my gosh, you here in front of me, you're the one person that really knows what's going on and I'm going to go with that. No. Many people are upset about our court system, and one of the things they forget or they never learned is a trial and the court system is not a search for the truth. It's not. It's a search for liability. And they're way different. For example, extreme example, if we really wanted to find the truth, we'd let the police go grab someone and torture him. Everyone will break at some point, and you see if he knows what color scarf it was. If he doesn't know, let him go grab someone else, torture them. For some bizarre reason, we don't do that. If the police exceed their power and break down the wrong door, exclusionary rule, trying to tell the police, don't mess with it. We're not worried about the truth. In this one case, this one defendant, getting off is less important than having you do what we think is socially correct. The same thing happens here. So the fact that the legislature is doing what the people believe is proper, and there's medicine to support it, they're not going to entertain a thought that this guy Jacobson is right and everybody else is wrong. And so one of the other things that lawyers talk about, or you may hear, is the procedural posture of the case. And this often is critical. Now, this shows up in Rule 12b-6. And people may say, oh, this is a 12b or this is a 12b-6 situation. Now, I've right here, if someone wants to look it up, you can also just do a search for the rules of civil procedure. And if you find it, it should be a 2022, December 1st, compilation. On page 20, you'll find Rule 12b-6, and it says, every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required, but a party may assert the following by motion. And a failure to state claim upon which relief can be granted. It later says you have to raise it before the first responsive pleading. And what you basically have, this was when I was clerking, my judge wanted to say it was the great writ of so what. He wanted to say, everything you say is true. We're assuming everything you said and that you pled was absolutely true. You still don't recover. Oh, I could say, oh my gosh, my grass is stressed. It didn't rain here, and Mobeen should pay me $500. He would say, yeah, I'm not going to argue whether it rained there or not. I'm not going to argue what happened to your grass. There's just no relation between your grass and me paying you money. So, hey, we don't have to go through discovery. We don't have to do anything. We just say you didn't understand what was going on. And even if what you say is true, so what? Doesn't make a difference. And so that's how each of these cases have come up in a 12b-6 motion. The future ones will. The Jacobson was an appeal from a criminal conviction. But it's essentially a 12b-6 because there's no factual development. I mean, a lot of times you have the facts, you'll hear witnesses and whatever, But in a 12b6, there can't be, because you're trying to avoid going through all that rigmarole if the thing stated doesn't do anything at all. My wife is a lawyer too, and our honeymoon, we went to Paris and then London. And we spent some time in the court system. That's a great place to go. There's no lines. You can get in right away. You don't have to buy tickets. It's really a neat thing to do, and we had fun with that. And I'm mentioning that because we had a contested divorce in London where someone wanted to divorce, and the husband didn't want the wife to divorce him. And she was off living with another guy at the time. And he went through, and her burden was to prove that his behavior was so outrageous it would be unreasonable to expect her to continue to be married to him. And her behavior was outrageous, his was not. And so the judge said to him, he said, "Sir, you have far more faith than I do in your wife, but I will not deny you the opportunity to try to save your marriage." This is exactly what a 12b6 is. They can sit there and say, "You are not going to win this case. There is no way you can prove all this stuff. But if you plot it right, we'll give you a chance. Go ahead. Show the United States, that NASA is wrong in how hydrofoils work, or whatever it is. Go try. You're not going to win, but we'll give you a chance." And so that's what happens when a 12b6 motion is overruled. Is it not saying you're going to win? And a lot of people look at it and say, "Oh my gosh, somebody won, then they lost. They won, they lost." No. They're simply saying, we're going to give you a chance to try to develop a case, and maybe you can win. It's not so outrageous that there's no developments of facts that could possibly show that you're right. Does that make sense to folks?
Yes.
Okay, does anyone remember the Indiana University case? Indiana was held, "Oh my gosh, the universities can force people to get vaccinated and whatever." No. That's not what it said. It was under this was under 12b6, and the university was saying, "Oh my gosh, students, you don't get a right to go forward and try to prove this, because what you're saying is outrageous, and you can never win no matter what happens." So here's what we know. They did a little discovery and some whatever. And there were 8 students that were of interest in this case. Notice Indiana University has 90,000 students. 8 were so upset they brought the suit. They couldn't even get 10. They're starting behind the 8 ball. And there's 40,000 employees, which will become important later on. And they say the 14th Amendment is that the university provide reasonable and due process vaccination program. That's what they had to do. That's the standard that the students are saying. It wasn't a reasonable, and they didn't have due process for the program. The university has 6 other vaccinations that are all required to attend, and they have since 1993. So if someone is saying, "I think just vaccinations are evil and wrong and whatever," they're going to look at it and say, "Oh, what's the difference with these 6 and the ones and the 7th? Is it reasonable with the pandemic going on right now that they added another one? Your objection that you think all vaccinations are wrong, that the fact that they didn't respect it and say 6 is enough, 7 is too much, they're not going to say that was not a reasonable and due process vaccine program." Of the 8 students, 7 received religious waivers before the case was decided and argued, or qualified for a waiver and said they might get one, which reduced the lawsuit to 1 person. Yeah, and the university said religious waivers were granted to every single person who applied without the university doing any examination, any questioning. If they checked the box, they got the waiver. Hard to argue how that's unreasonable and not allowing due process to get out of a vaccination that you don't like. They said they had no plans to change the review or approval of waivers. There was no real singling out of waived students with different requirements. I mean, they had to do more testing, they had to have more masking, but some of the students that had the vaccinations, if they tested positive, had to mask, and they had to be tested, just not as often. So they weren't being singled out. They didn't have from the old book, a red A on their jacket showing that they were vaccine deniers if someone was walking around wearing a mask. And my bet is probably at least a third of the students were masking the whole time. So there wasn't any real distinguishing or singling them out, which might tend to say that would make it unreasonable if they said, oh my gosh, if you're not vaccinated, you have to have a mask with a V on it, or, you wear breathing air when you walk among the other people. No, they didn't do that. And this is what the court also said. Government agencies and collegiate associations have with one accord promoted vaccination to address COVID-19 pandemic, although they typically have remained silent on whether universities should mandate a vaccine. Today, more than 500 colleges and universities have mandated vaccination, although many are private institutions of higher learning, not public universities. And so again, it goes to what is reasonable. You take a look at what other people have done. And what better thing than to look at what other universities looking at exactly the same thing have done. So this, as you may remember, this is very, very similar to the Jacobson court saying most people or most doctors believe something. And so again, we're looking for something that's unreasonable. And again, some people get really excited and say, but it's not right. They're all deluded. Well, that doesn't matter. Where it's not a search for the truth. You ask the question correctly, almost all lawyers will eventually tell you that. Now let's look a little more at their unreasonable process. This is what the students are arguing, that it's unreasonable. It goes back, I think, to the divorce that I was talking about. Their executive vice president of the university for the university's clinical affairs and the student of medicine's dean spearheaded this committee. It included 15 members with expertise in health, epidemiology, virology, data modeling, monitoring, risk mitigation, health equities, health science, and the law. The committee had 7 MDs, some with additional degrees in public health or PhDs, graduate studies in public health, risk mitigation, law, and ethics. I mean, this wasn't a case of 2 bureaucrats getting together and deciding over a weekend that they're going to do something. And for those that had received the exemption, they had 2 specific requirements, and it applies to 6 of the 8 who received the exemption, and potentially a 7th must participate in more frequent mitigation testing. It says mitigation testing. I think they meant COVID testing. Quarantine themselves if exposed to someone who tested positive, because they were viewed as a more virulent carrier, which now is not being viewed as medically correct, but at the time it was. Wear a mask in public spaces and return to their permanent address or quarantine if there's a serious outbreak at the university. That's it. That's all they were being asked to do. And they noted that the vaccine campaign had markedly curbed the pandemic, which again goes to the point of how reasonable the university is in imposing it. And the university reasonably believes the vaccine promotes safety, not only of its students, but of the entire community. So the university went and said, yeah, students might not get hurt too much, but we have all these employees. We have all these people living in the community. The students focused only on students. That makes it really hard for the judge to say, hey, I live in this community and I'm not part of the group that's going to get protected. We're only worried about students here at the university. And of course, the university has all these things talking about being a good corporate citizen and, helping everybody and hiring people and how much money they pay in salaries and how much sales tax comes out of them and all that. unless there's a sales tax exemption for Indiana. I don't know. Dr. McCullough, in fairness, had a wire snapshot, yet pointing to a longitudinal survey, blood sampling of the community residents near Pennsylvania State University. The students experts didn't even get data from Indiana. The court is not going to, here we have the Indiana University. That's the flagship for Indiana. They have all these doctors and all these people in the university that are doing their stuff. The students bring in some guy from Pennsylvania State. Yeah, they're not going to do very well. Then they were able to show that the University of Poly had broad support within the community. And over 42,000 of their students received the vaccine, and they probably more. 2 university faculty councils issued statements in support. The Staff Council, Indiana, endorsed it. The Graduate and Professional Student Government Associations issued a resolution supporting the policy. The court's hands are tied. There's no way this court can reasonably say the students win. And they did say a future case might raise what the medical exemption is, but not today, because everyone that had a medical exemption also got a religious exemption, and they said we're granting those without even looking at them. So we're not even going to look at that part of it. And so again, someone could look and say, well, what was the medical exemption policy for the University of Indiana? It's like, well, the court didn't even look at it. There was no reason to. So that's it for the University of Indiana that I have. And any other questions or concerns about it? When I first read through what the university did, I thought it would be hard pressed to come up with a more fair and reasoned decision. Now, I may disagree with some of the conclusions based on new science, but as of the time they did it, I think the university was bending over backwards, and you only had basically one student that ended up in the lawsuit going forward. That's incredible. I would think you could get 1,000 students to oppose anything.
Interesting.
Let's review again the Palmerix case against FDA and CDC, I think it was. They asked for the court to say sovereign, and again, they were dismissed below. They were dismissed below. They were told, no, you can't proceed with your case. There's no development of the facts that you pled that is going to allow you to win. We're not going to let you do it. And so the things they were looking for in their suit, they wanted that sovereign immunity does not bar a lawsuit. Well, CDC admitted that in their argument. FDA, CDC have no power to prohibit the use of approved drugs, off-label use. CDC admitted it. Again, this is what I argued back when CDC was doing these things. And if you remember, I said the best number I could get was between 30 and 40% of the prescriptions are for off-label use. His big high-powered law firm got the same number. So that was reassuring to me. And FDA, CDC has not prohibited the use of drugs. FDA said they didn't. They were just joking around. They're just sending tweets out. They weren't telling anybody anything. We got the off-label use. They wanted that CDC, FDA is not licensed to practice medicine. They agreed to that. They cannot insert themselves in the patient relationship. They got that. Now, CDC and FDA said, we didn't do it. That's a different issue. But the results they were wanting, because they're not going to get the court to say, FDA, CDC, they could say you did it wrong before, but the important part is going forward. You're not going to do it again. And they asked for them to pay attorney's fees, which of course they haven't gotten that yet, and I don't think they will. And then that others, the third parties, should pay for the interference with their employment and their patient relationships. And they haven't really gotten that yet, but I think they've gotten the major part of it, because before this case came and was argued, a lot of people would have thought it was reasonable for a hospital to fire someone based upon what the CDC and FDA said about using ivermectin or hydroxychloroquine or any of the other stuff. Now that the FDA, CDC has said, no, we're just joking around. We're just providing information. We're not telling anybody anything. Now, if I'm a legal counsel to one of those groups, I say, whoa, we got to make our own independent decision. If you just say we're following CDC, that's not going to fly because they said we're not leading you anywhere. So again, I think this is a case that no matter what happens below, and I certainly hope Palmerix and his other folks win and go forward. But even if they lose everything from now on, they've gotten almost everything they possibly were asking for. So again, all the things that we were worried about, we've improved stuff now. We now know if somebody thinks that the Army Corps of Engineers sending a text message off is something that you can follow and rely on as government instruction, it never was. As I said, it wasn't. They have to speak to their rules. And anyone that gets confused now, we've got a case that says you really can't do that. They have to go through notice and comment and rulemaking or have an emergency order or something else to go forward. So we've really improved the law a bit here. Unfortunately, every time there's an improvement like that, somebody has to suffer inappropriate harm in order to get the new rules out. And, you know.
So I have a quick question for you. So
yeah.
Someone is very much curious that you are a teacher or a lawyer. They don't believe you are both. So what is your answer?
Well, right now I'm being paid by a university to teach law. So yeah, I am a lawyer and I am a teacher. I've taught from the second grade all the way to, I got an MBA at LSU. The year after that, they asked me to teach in the LSU MBA program. So I did that for a while. So I have taught all along, and I certainly think a large part of my representing clients was teaching them things. So yeah, I'm a teacher, I'm a lawyer, I'm an engineer, I have an MBA. I'm tired of going to school.
Excellent. Thank you. Back to you.
Except they're now going back to school under Mobeen learning, but he has nice drawings, so that's good. Now let's talk about the Los Angeles Consolidated School District case. I've got a reference to the law firm that did, or the organization that hired the law firm. The law firm and the organization are somewhat entwined, okay? It's sort of like the, from environmental things, the NRDC, the National Resource Defense Council. They show up in cases and they have captive law firms that just represent them and whatever. I remember arguing with some of their counsel on things and very quickly realized we had a different worldview and we were not going to agree. So anyway, this law firm is out of Wyoming. And they're related to a plaintiff because the Health Freedom Defense Org is a plaintiff as well as the individual teachers. The teachers joined this Health Freedom Defense, and then they were able to cite that some of their members had stuff, so they have independent standing. Of course, the Los Angeles Consolidated School District doesn't think it's right for anyone outside of California to be able to sue them, so they've objected to that. And so we have here that this is a national impact, that we're having people all over the country worrying about how things are and what's going on. You know, the FDA, the CDC are national. We're having lockstep progress from a lot of the supposedly independent actors dealing with medical licenses and dealing with pharmaceutical licenses and all, and school districts and other folks. And you remember that, do many of you remember the story what Syed Haider, Dr. Syed Haider talked about how he got to prescribe?
Yeah, I remember the Crow Nation or the Crow tribe. Yes.
Right. Because he said, I can't. And apparently one of the people looking for it, I'm guessing, was a Crow. And they said, well, our rules override the state rules. So if we make you a Crow doctor, you can prescribe to our Crow nation. And he did. And then they said, given how kind Americans have been to the Crow, we're going to allow people to come in and become members of the Crow nation so you can treat them in this pandemic. I think that was just an amazing blessing that the Crow nation gave to all of America, to have people all over in all the states be able to get out from under their state rules and laws that were causing trouble. Following the jokes from the CDC. Some may be unkind and say the CDC is a joke, but the CDC says they were joking.
Yeah, they were quipping. And they also said there were no legal binding of whatever they were saying.
Right. And so the question is, what does it mean? And they were dismissed for failure to state a cause of action. So they were sort of like what happened to Jacobson. And here's the order. This is the entire order that dismissed it from the United States District Judge. Having granted a motion for judgment on the pleadings, 12b6, and the plaintiffs not having amended within the time allowed for the court, because one of the things that happens is if the court says you didn't plead it, and if we assume everything you said that you pled was right, you still don't win, you get a shot at, let me amend it and put something new in here that lets me win. Okay. They didn't do it. There wasn't anything else to add. Therefore, it says dismissed with prejudice, you recover nothing. You take nothing. This is just like the chocolate factory, where remember at the end he says you get nothing, you take nothing. This is the same thing the judge is doing to him. This is just normal. They say that they take nothing. The action is dismissed with prejudice. Defendants recover cost. So the defendants are going to have to pay the health board. Okay. What happened before in this lawsuit, one of the reasons that they're upset, in March 4th, the Los Angeles Consolidated School District adopted a COVID policy requiring vaccination. March 17th, the Health Freedom Defense Fund filed a lawsuit. March 18th, they changed the policy and then argued, hey, our policy's changed. You should dismiss the case. Now, courts sometimes do that, but sometimes they say, wait, the case is as of the date you filed it, not as of today, the date you argued it. So, for example, if we're looking at medical knowledge and trying to justify whether Paul should have been fired or whether this doctor should have been suspended, we can't go and look at what the medicine is today. We have to go look at what it was at the time. And the same thing with the justification for what the Illinois University of Illinois University did. So here they did that, and 17 days later, okay, so the case was dismissed on July 27th. 17 days later, on August 13th, they adopted a new policy, almost identical to the old one.
That is not nice. Interesting.
Right, and that may be part of the reason why the judges were saying, is the policy still in effect?
Interesting.
And you don't get to see this if you don't go back and look at some of the pleadings that they have. So, and the new policy required a vaccination by October 15th. Oh, the new policy was different in that it said if they were vaccinated before, after a certain date in 2021, they didn't have to be vaccinated again. That's the part. And remember that the judge was like, this is years old. Why does it make a difference? Well, the reason is that was the policy that they adopted, and it was a reasonable time before it when they adopted this policy, 17 days after the prior case was dismissed. So they require a vaccination by October 15th, 2021. They had to get vaccinated by then, and if they weren't, they were supposed to be fired by November 1st, 2021. And the firing actually occurred early December 2021. Far enough away from Christmas so it didn't really interfere with the HR people's Christmas and just upset the people they were firing. Anyway, and part of the discovery says, interestingly enough, it was unanimously passed, and none of the board members that we've sued say they remember having anything to do with it. Okay. So we have that Jacobson says smallpox vaccine is okay. This is part of what is being argued. Is Jacobson said smallpox vaccine is okay. Curzan, in 1990 Supreme Court case, said refusing unwanted medical treatment is not okay to enforce it, and it's okay to refuse unwanted medical treatment. And then we have the Glucksberg, and you remember that case being cited by the lawyers as they're going by. It was a 1997 case that said there's a fundamental right to refuse unwanted medical treatment. Fundamental right are the key words legally that trigger additional obligations on someone that wants to take away a fundamental right versus not. Schools have a complete control over the environment. They have a lot more ability to change things than employers or governments that aren't having kids in school or whatever. So, okay. So this is what we have here, and we'll see what the court did. You saw that they were very antagonistic towards the Los Angeles Consolidated School District, and part of it, I'm sure, is because they feel like they were played for fools when they changed the policy right away. And then she said, I can't answer the question whether it's going to change or not. She was just really snarky to them, which is usually not a good tactic when you're looking for them to help you out. But I had the feeling that perhaps the lawyer that's representing them, and it'd be a silly idea, but I think it probably happened, is that she's the one that wrote the policy and she's arguing it and she's providing all the stuff. And so the common rule is a lawyer that represents himself has a fool for a client. He may be a good lawyer, but he has a fool for a client, and you can't do both. I mean, you saw Top Gun, right? In Top Gun, they're at the very beginning, they're going around, Jasper's after him, they're trying to shoot Jasper down, and they're both looking for Jasper, and then Goose says to Maverick, the mountains, do your pilot stuff, let me do the looking for Jasper thing. You're looking for Jasper, we're going to run into something, you have to focus on it. Same thing with lawyers and clients. If you have if the legal representation captures the client's role, then you don't have a client to make client decisions to say, well, yeah, we may still win, but nope, we're going to bankrupt the business in doing that or whatever. So I think the consolidated district should have given up on this a long time ago. And I think the court's saying the same thing that we heard in Jacobson and the same thing we heard in Indiana. What is everyone else doing? If we're doing what everyone else is doing, we're probably doing it right. And if we're not doing what everyone else is doing, maybe we got a problem. Everyone else has stopped this. Why are you still doing it? Why are the students, if it's really important, why are the students not subject to this and just the teachers? Actually, there's two electricians, there's a teacher's aide, there's a medical, there's no teachers. There are no real teachers that are involved in this lawsuit. And interesting enough, no administrator. Anyway, so now let me just talk about other countries. And I told you about, there's no wait. If you go to a country and you're visiting a country and you're looking for some interesting stuff, you can get into the courts and see it. No waiting, no tickets. Get good seats. And I really love our Constitution. In the UK, you're not allowed to represent yourself in court. We saw a case where a lawyer was fined the equivalent of $35,000 for practicing law without a license because he hadn't paid the local bar dues, and the president of the local bar was the judge in front of whom he was appearing. And as he's starting to argue why it's wrong, the judge says, excuse me, have you paid your local bar dues yet? I said, no, Your Honor. Well, then you're not licensed to practice law. Would you like a second offense? Turned around and walked out. I guess you lose because you can't argue. In France, there's a rebuttable presumption you're guilty of all the crimes that are charged, and it's your duty to prove that the government is wrong. You can imagine how often that works. There is no jury. The judge decides. And the judge is also the primary questioner. We had a case where someone was apparently stealing money from tourists. And the allegation was that when the constable came in, the gendarme, and was trying to collect him, he got in a cab and told the cab driver to drive off. The tourist evaporates, isn't around. We don't know who he is, where he went. And the question that the judge thought was a good one, in French, of course. My wife speaks French, so I trust her translation. When the constable gave you the lawful order for you to stop, and you subsequently entered the cab and told the cab driver to go on, my question for you is, had you heard the lawful order? That was how he's questioning it. It's like, yeah, well, okay. Anyway, when we went in, they had 7 officers in the court. They all were armed with submachine guns. The defendant was in a locked cage. The judge entered, offered a salute to the officers, saluted the judge. He saluted them back. Just so you know, we're all on the same team here. And in the old Soviet days, there was an irrebuttable presumption you were guilty of the crimes you were charged. The only purpose of the trial was to see if you had accepted responsibility for your crimes and thus needed to be punished less. A lot of Americans that were over there were surprised to hear their trial counsel tell them, oh, you're going to be convicted. There's no question about that. That's not what we're here for. Anyway, sometimes we have perhaps the same kind of thing going on in certain countries. Now, how long have we taken?
We are 1 hour, 7 minutes.
Okay, let me just quickly run through. Nothing much changed on the COVID stats themselves. Here's the UK. It's still coming up. It's about where it is. There's an inflection point. It's starting to curve down, so we should have a peak maybe right about there, okay? Nowcasts have given up. Only half the U.S. regions are even being covered, so I don't know how they can predict for the whole U.S. They aren't even predicting for the regions. These are the growing variant classes. They're all derived from the BA2 and the XBB under the BA2. Mutation rate for next strain, which the only current one is the EG 5.1, shows that maybe it's down about 20%, but certainly we're not getting an increased rate of mutation. Here are the latest numbers for the CDC for hospitalizations up 7%, deaths up 4.5%. And that's it.
Got it. Thank you so much. So number one, thank you for doing this roundup. If Cool Beans liked it, I think we'll continue either weekly, bi-weekly, whatever is the right cadence. And Cool Beans, please let us know, what did you think about this? And Paul, thank you very much for pulling all this information
Also,
together.
if they would like to have more, tell me what case to look at, because I think we've sort of covered the critical cases that we've seen. And if there's something in particular or something, and even if it's in another country, I can make a swing at it. But
I think there is an interesting case here in California. Remember, California had passed a law saying that if you are talking with your doctor and the doctor says something out of line with the local authorities or CDCs,
right,
then you can report the doctor and the doctor can lose their license. I think that law has been challenged.
Okay.
So it will be interesting to see what's happening with that.
We can take a look at that. That law was only passed a little while ago. These administrative things tend to take a while to be sorted out, and jumping in the middle of it, just like, Merrick's case and the other ones, it's a lot easier to know what happened when it's all over. It's just, we're a lot like, lawyers are a lot like the weathermen. There's 50 different reasons why something happened before, but trying to tell you what's going to happen tomorrow is a little more difficult.
Got it. Thank you very much. And Cool Beans are saying thank you for this presentation. They like it. So once again, thank you very much. And Cool Beans, thank you very much for being here on a different kind of a talk today with the law. And I would see you tomorrow. Paul, thank you.
You're quite welcome.